Welcome to the Dead Celebrities Podcast. In this podcast, we break down high-profile celebrity estate planning cases for advisors and their clients. Most celebrity estate catastrophes are based on the same issues that everyday people face, just with the volume turned up. Our goal is to identify and extract the individual estate planning issues that lie at the heart of each story. We then discuss what advisors should expect and how to avoid common pitfalls. Hosted by wealthmanagement.com senior editor David Lenok.
Hello, everyone, and welcome to the latest episode of Celebrity Estate Planning Podcast presented by wealthmanagement.com. My name is David Lenok, and I'm a senior editor with Wealth Management and Trust and Estates. For those of you who are new to the podcast, each episode focuses on a single celebrity estate, be it a planning snafu, a familiar fight, or even just a good example of the power of proper planning. And from that high-profile and often ridiculous example, myself and a guest attempt to boil the example down to some lessons that advisors can use with their more typical clients. The idea being that celebrity estates, though the details are often more bombastic, generally face the same obstacles and issues as those of regular people, just with the volume kind of turned up, which makes them interesting and valuable case studies. This week we're throwing a bit of a curveball. Previously we featured mostly estate planning professionals, largely lawyers. However, our guest this week is a doctor. So Dr. Stanley Teitelbaum has been practicing clinical psychology for more than 35 years. Since 1980, he's been a training analyst and senior supervisor and faculty member at the Postgraduate Center for Mental Health and also the Training Institute for Mental Health, both in New York City. He's a founder of the Contemporary Center for Advanced Psychoanalytic Studies in New Jersey and also the author of numerous books, including Illusion and Disillusionment. Thanks so much for joining us, Dr. Teitelbaum.
Thank you. My pleasure.
And today our celebrity is, we're going to talk about one of the old Hollywood sort of biggest names, biggest stars, Joan Crawford. Joan Crawford made more than 80 films, and she won an Oscar for Best Actress in 1946 for a performance in Mildred Pierce. Famously prickly, Joan was part of perhaps the greatest feud in the golden age of Hollywood with Bette Davis. It's once reported that Davis once said of her, "The best time I ever had with Joan Crawford was when I pushed her down the stairs in Whatever Happened to Baby Jane." Crawford was married 3 times to Douglas Fairbanks Jr., Fran Chautone, I'm sure I have butchered that name, Philip Terry, and Pepsi-Cola President Alfred Steele. Unable to have children, she adopted and raised 4 of them, Christina, Christopher, and then twin girls, Catherine, Kathy, and Cynthia, Cindy. Her relationships with Christopher and Christina were fraught with difficulty and resulted in estrangement. Christopher's last contact with her came in 1962, while Christina last spoke with her in 1968. Crawford herself died in 1977 of liver cancer, and she left an estate valued at around $2 million. In October of 1976, she had made a will leaving a trust fund of $77,500 to both Kathy and Cynthia, and then $35,000 to her longtime friend and secretary, Betty Barker. And she made many smaller bequests to a few other people and some money to her favorite charities. The will did state specifically that Christina and Christopher had been knowingly and deliberately left out. Quote, "It is my intention to make no provision herein for my son Christopher or my daughter Christina for reasons which are well known to them." It turns out Crawford just couldn't understand why it turned out so badly with her 2 older children. She once lamented, "I couldn't make them love me, but they could have shown some respect," which I think is a bit instructive as to her mindset. Along with the trust fund, Kathy also inherited all of Joan's property, including the 1946 Oscar for Mildred Pierce, which sold for $426,000 in 1993 at auction. Christina and Christopher unsurprisingly contested the will, arguing that due to Joan's heavy drinking, she lacked the requisite testamentary capacity and had been unduly influenced by Kathy and her husband to change the will in their favor. The estate eventually settled with Christopher and Christina, and each received $27,500. Following Joan's death, Christina wrote the best-selling book Mommy Dearest. It was the first tell-all celebrity memoir, which discussed openly a psychologically and physically abusive childhood. It's a cultural phenomenon, and it stayed at the top of the New York Times bestseller list for 42 weeks. It was also later turned into a cult classic film in 1981, which is most notable for bringing the phrase "no wire hangers" into the common lexicon. Regardless of Crawford's pugnacious reputation, sort of unequal inheritances like this and even outright disinheritance, these aren't limited to the halls of Hollywood royalty. They're very common issues among every type of client, so many advisors are going to cross these. Dr. Teitelbaum, in your experience, what do you think, where do these sort of things come from?
Yeah, just one further note on Joan Crawford. It was interesting. You mentioned a 3rd marriage to Mrs. Steele, who was the president of Pepsi-Cola. And upon his death, she became the president of Pepsi-Cola. So she was a very, very successful woman in film and in the world of business. The thing that you mentioned was respect. The thing about respect kind of bridges her concern about her children could have shown more respect, and that's why she chose to disinherit them. that bridges a number of emotional reactions that many clients have when they're considering either unequal distributions or disinheriting. Things like disappointments, things like the lack of appreciation, things like unresolved conflicts that have never really been dealt with sufficiently, and respect. I call it the Debruce Syndrome, D-A-R-U, the Debruce Syndrome. And among the clients that I get to see as a psychologist, they come into a number of typical categories. One category has to do with the feeling that the client is considering unequal distributions or disinheritance because of this element of disrespect, and that has simmered within them for a very long time. And it relates to their feelings of vulnerability, their feelings of helplessness, and their feelings of resentment and anger. And by crafting an estate plan with a will that goes in the direction of inequality or disinheritance, it becomes, in a sense, a payback for the hurt that the client has experienced usually over a number of years or periods. So that's one category. The second category of people that I get to see with psychological issues has to do with their concerns about, if I go forward with my thoughts, with my plan, with my decision about disinheriting one or more of my heirs or unequal distributions, will that create harm among my heirs? Will that create ill feelings, bad feelings among the heirs? And that becomes a very tormenting process for many clients that have a lot of difficulty in sorting that out and coming to some conclusion with that. And that's where counseling sessions tend to be very helpful. The third category of the people that I get to see with these issues have to do with couples who are, between the two of them, are not on the same page. Mm-hmm. So it's not unlikely, it often does happen that, one parent feels one way about how to proceed with unequal or equal distributions, and the other parent has a very different reaction or very different preference for that. And so that often creates a lot of disharmony in their relationship, and that's often one of the things that gets them to come to see a mental health practitioner. Parenthetically, I've found in working with couples, it's a very difficult thing often for couples to get to do, and there have been some studies that show that couples in conflict often wait sometimes as long as 8 years before they pick up the phone to make that first appointment with a psychologist to help them with their issues.
So, we mentioned at sort of the very start of these concepts of respect and disrespect. And so these are all, it seems like they're all very nebulous sort of motivations in their way. And then that it's, almost like even the person themselves can't really explain why they're doing what they're doing. So they resort to this sort of nebulous terminology of respect or disrespect, or this person was nice to me or not nice to me. Obviously, most estate planners, most financial advisors are going to be psychoanalyzing their clients. They're not sort of prepared or trained to do that. Right. So what can they do, or what can they look for, when sort of faced with the specter of these unequal inheritances, to try to smooth the road and to make things so it's not, a huge fight?
Well, what I find is that when the estate planners relate to these clients what comes out becomes somewhat nebulous, like you say, the task at hand is to make what sounds nebulous somewhat less nebulous. And that is not necessarily all that complicated for the estate planner to do. It's very complicated for the estate planner to work with and resolve. But oftentimes the client that comes to the estate planner with this kind of situation, in contrast to the nebulousness, is ready to spill. They've been sorting this out. They have hurts. They have disappointments that have gone back for a very long period of time. And so the estate planner can begin to ask a little more questions, not to pursue it deeply, because that's not his or her province, but to ask some more questions, such as, when did this start? How far back does this go? What is the history of your hurts and your disappointments? How much anxiety do you have about it? Do you lose sleep over it? These are all questions not only that the therapist, like myself, will ask the client, but initially the estate planner as well can begin to touch on some of those questions, which will give him and the client a better grasp on the magnitude of the problem at hand. One of the categories that I mentioned earlier that comes up a lot is like an example of what's not nebulous. I get this very frequently. Is a situation where a client is very upset or angry or resentful toward a particular heir, a particular child. And that often has to do with the child and that child's marriage. Mm-hmm. A not uncommon scenario that I've seen frequently is a source of conflict between the mother and the daughter-in-law. So that in which the mother feels that the daughter-in-law, complicit with her son, have distanced themselves from the mother, and this harbors a lot of resentment in the mother, mostly toward the daughter-in-law, but also toward the son for not having stepped up more, for not having participated more in working out a better situation with his wife in order to keep or maintain a better relationship with the wife. And
so a feeling of betrayal of the family.
That's right. A feeling of betrayal from the son, but of disrespect in a sense from the daughter-in-law. And I'm reminded of that old expression that goes, a daughter is a daughter for the rest of her life. A son is a son until he finds a wife. And so many of these situations that I'm describing have to do with, the sons who are married to someone who doesn't have particular fondness for her mother-in-law, and that gets displayed, and that creates a lot of conflict for the parent, in this case the mother that I'm describing, and she harbors this and doesn't have a palatable way to address that or to make it better. And so ultimately she may resort to some desire or some wish, some plan to pay back, to express her anger and resentment toward the daughter-in-law and toward the son who have disrespected her in these ways by creating an estate plan that doesn't treat them equally with other siblings, other children, other heirs, or in some more drastic extremes, disinheriting one or more of their children.
Mm. So this is a problem. We've been talking about it from the side of your client, especially as an advisor. If I'm an advisor and my client comes in, but this is a two-sided problem, right? There's this whole aspect of the people who aren't my client, who are embroiled in this as well, the son and the daughter, or whoever happens to be doing the disrespecting. At what point is it appropriate, or is it ever appropriate, to attempt to bring the group together and resolve these things? Because it seems as if a lot of the outrage and these conflicts at the end stem from a combination of, not understanding why they're being disinherited, the surprise of the disinheritance, and then just the fact that they're being disinherited. So there's just sort of three prongs, there's a lot that goes into it. It seems like maybe trying to bring the family in to talk about it will head some of these things off, maybe not all. At what point is that appropriate?
Yes, it can be appropriate, and it can be very useful. Let's think of it as a process of steps. And I think the first step would be the estate planner to make an assessment that something is happening here. There's some major issue here, some major conflict here that needs to be pursued with a mental health counselor, with a practitioner like myself, for example, and to be able to normalize that for the client by way of saying, these issues, what you're struggling with is not unusual. This happens all the time in many different ways. So, I'm going to recommend that you have some counseling sessions, and don't think of that in any way as a statement of your mental health. It's very common. It's very normal to have these kind of questions. So, step 2 is for the client or clients, if it's a couple, to be able to go to a mental health professional and discuss and explore the history and some of the roots of these issues. Along the way, when that is accomplished, it may also, in response to your question, it may then also be very useful to suggest that we bring in the other people, to bring in the other family members, to bring in the heir in question, so that maybe there's an opportunity to better deal with the unresolved issues before you go to any final conclusion or any final decision. Now, bringing them in is in no way a promise to the heir that you're going to do what they want necessarily, but to be able to, once again, try to resolve issues which often case have not been comfortably sorted out or dealt with. So I think that needs to be an option in the mix.
So, it seems as if, pretty obviously the estate planner or the advisor should not be tackling this on their own.
Right.
They can get to know their own client, but then once they realize there's a problem, it's time to reach out to the pros.
Well, the more the estate planner could be aware of the kind of issues that we're outlining today, the more he could feel or she can feel comfortable in making this recommendation. And so, in a sense, it becomes part of a team between the estate planner and the psychologist to be able to be most helpful to the client. One of the issues, I'm interested in your question because it doesn't always come up about, what about having sessions not just with the client, but also with the heirs? And one of the things that also comes up in the mix is that clients often have some concerns about the decision that they're thinking about in terms of how much will my heir, my son or my daughter, approve or disapprove of my decision. And that's something that often goes pretty deep in the history of the client because, when we're kids and we're growing up, we very much want or need the approval of our parents. But very frequently, that very need gets transferred, we call it transference psychologically, but that need gets transferred onto our children. And so people sometimes get caught up in how much will my child, my heir, approve or disapprove of my decision, and then that becomes another factor to be sorted out and resolved. Ultimately, the clients need to find a way to also be fair to themselves in terms of how they're sorting this out and what makes sense to them and how much of the decision is based on emotional decisions and how much of the decisions is based on logical considerations. For example, if there are two children and there are, let's say, $2 million in the estate, instead of designating $1 million to each child, which is the equal option, and very often that's the simplest option.
Not enough scare quotes in the world for equal there.
Yeah. That's easy and hopefully dispute free, but it's not always the most meaningful or the best solution because one child may be, and I can't tell you how often this happens. Two heirs are not equal in their level of financial success. So it's very common that one child may be more financially successful in the business world, for example, while the other child is a school teacher and living on more moderate financial economic situations. Or that one child, in another situation, one child is doing pretty well, but the other child has some health issues, significant medical needs, and may need more financial help in relating to that. So, these are among some of the more logical reasons for considering unequal distributions, even if it's not the most easy or most popular thing to be doing.
And I think it's a good thing to bring up, right? I mean, we spend a lot of time talking about these situations where there's some sort of animus involved and it's a punishment. And, I think more often it's going to come up in this situation where maybe one child was the caregiver and the other wasn't and kind of put more in. Mm-hmm. And it's not a sign of I love this one child more than the other, but it's like this child was there for me more, or this child needs it more and then financially than the one you put in. And that there's no animus. That they're trying to be as equitable as possible, where if one child needs it and the other one doesn't, well, is it equitable to give them the same amount? I think that is a lot of times the more common situation that comes before estate planning attorneys and in ways the more difficult to work out because, there is no animus that you can try to solve there, right? I mean, how do you work with that?
Yeah, if there's no animus, you go back to the previous point, but then it becomes easier to just do an equal distribution. Mm-hmm. But if the client is considering the circumstances of each of the heirs, then they may move more in the direction of an unequal distribution, and that may create animus among the heirs, regardless of the logical situation. Now, I know one estate planner that runs into this very frequently, and he has come across a pretty good solution. I think I'm not a estate planner or a financial advisor. I'm a psychologist, but this has stayed with me because he considers the example of designating equal portions to two heirs. Let's say in that situation, equal portions to two heirs, but a third portion which is designated for health issues, whether it's physical health or mental health or whatever the health issues, that becomes a health fund to be used by the person who may have more health needs or the other person who in the future may find they have more medical or health needs. So that becomes one way for a planner or an advisor to sort that out and to work with the clients on that issue.
Yeah. Well,
one other thing I would introduce there is, we often think emotionally or psychologically about conditional love versus unconditional love. And, it's very, very nice to think about, I love my children and I love my children equally and I have unconditional love to my children. But, in the real world, there probably is no, unconditional love doesn't fully exist 100%. There are always issues. There are always things that go on that get introduced into the relationship that may not necessarily allow the client or the parent to maintain a position of unconditional love, because children will do things that upset the parent. Where I'm heading with this is that our world is changing so quickly now, which means that there are so many more options that people that in our conversation here today, that children, that heirs, there are so many more options that they have in how they're going to pursue their lifestyle, who they're going to marry, or what lifestyle they want to pursue. There's so many more open possibilities for that, and as a result, that creates many more possibilities for disappointment on the part of the parent as to how my son or my daughter is determining to live his life. And so that feeds into more issues around unconditional love and the resentments and I'm thinking also about the Jerry Lewis situation that you had mentioned to me off target, and how with one of his sons, who he would have disinherited, except he died. But Lewis had said, well, he's a dope addict, and he dismissed him because in his mind, being a dope addict meant he didn't deserve to get any financial backing from me, because that money would go more toward his fix rather than toward helping him.
Mm-hmm. You mentioned a lot of these are sort of heavy issues that are outside the purview necessarily of above the pay grade in a way of your typical advisor. Financial advisors and estate planners and wealth managers in general sort of are always talking about collaborative effort, and especially as you go higher up the net worth scale, your clients expect more and more complete advice from you. But I don't think that many estate planners and many advisors have a psychotherapist on file that they can refer a client to. Is there a central database? Is there a good source to find, if I'm an advisor and I see this and I realize this is beyond my, I've gotten as much out of this as I can, but this is beyond my ability to try to fix this family, but I don't know who to send them to. Is there how do I find, a mental health professional?
I think the problem is not in how to find someone, because we're very easy to find, and there are many organizations or societies. I belong to a number, the American Psychological Association, New York and New Jersey Psychological Association, and so forth. There are many ways to find a therapist. The important question is for the advisor or the planner to be aware of this possibility, to be aware that it's useful, it could be helpful, and that it could be a step in collaborating. It's not often part of their thinking that collaboration is going to work. And sometimes even there's a concern in which an advisor may feel threatened that if I send this client to to a mental health person, I may lose some of my connection to the client. It becomes somewhat territorial. So collaboration is extremely useful, but the advisor, it really has to start with the advisor. It comes first from the advisor to have the awareness that this is a step in the right direction, and then to know how to pitch that, to know how to convey that and explain that to the client in a way that can become more helpful.
Well, we're running out of time. Thanks so much for joining me today, Dr. Teitelbaum. This has been really sort of a very interesting conversation, and certainly outside what we normally do on this podcast. And that's really all we got here. So do you have any sort of parting remarks, any sort of ways, something, the last thing that advisors should know about these disinheritances? Or
that it's very normal, that you need to be able to work with your client in a way that has compassion for their problem, and to have empathy with it, and to proceed with them in a non-judgmental attitude, and to normalize the conflict, and to be able to tactfully introduce the notion that this can be more advanced. We can work this out in a better way for you if you can make yourself also available to consider having a consultation or a number of consultations with a mental health professional.
Mm-hmm. Well, thanks so much for joining us, Dr. Teitelbaum. And for our listeners, we'll see you next time.
Thank you for listening to the Dead Celebrity Podcast. Click the subscribe button below to become notified when new episodes become available. The information covered and posted represents the views and opinions of the guest and does not necessarily represent the views or opinions of InformaWealthManagement.com. The content has been made available for informational and educational purposes only. The content is not intended to be a substitute for professional investing advice. Always seek the advice of your financial advisor or other qualified financial service provider with any questions you may have regarding your investment planning.